to Obuasi as a community tribunal chairman. Whilst in Obuasi, I was handling the community tribunals at Hontado, Bekwai, and New Edibiasi. In 2000, I was elevated. I was promoted to the Circuit Court.
Chairman, we have the CV, so.
Thank you very much. The 2 minutes is over. Without any hesitation, I proceed to give the floor to Honorable John Dako based on the agreed rules to ask one question.
Thank you very much, Mr. Chairman. My love and respect, I have perused a lot of Court of Appeal judgments, and I see a lot of them, where about 80% of the judgments I've read are unanimous. And so I want to find out from you, do you think that it would be fair for anybody to refer to the Court of Appeal as a unanimous FC?
Honorable Chair, after the Court of Appeal had heard and adjourned a case for judgment, a judgment conference is held where we have a debate, and at the end of the day, we come to a decision as to whether the appeal should be allowed or should be upheld or should be set aside. And where we agree that the judgment should be upheld and it is a unanimous decision, then one of you will write the judgment. Where one of us disagrees with the judgment, then you have to write a dissenting decision. But the fact that a decision of a court is unanimous is not anything derogatory.
Thank you very much. Any follow-up?
And so, my Lord, with respect, you will not agree that calling a court unanimous FC is a good thing, would you?
Honorable Chair, as I indicated, the fact that a decision of a court is unanimous is not a derogatory term.
Yes.
Thank you, Honorable Chair.
Thank you. I then proceed to give the floor to Yes, Honorable Tampuli, you have the floor. The same rules.
Thank you, Mr. Chair. Mr. Chairman, I would crave your indulgence to vary this one a little. I have noticed something on page 2 of the document that was given to us in respect of Justice Subare's CV, the BNI report. And if you permit me, I will just read bullet point 6 for clarification.
You have to ask question. You can choose wherever the question would come from.
It's just for the records. This is just for the records. So I just
the rule is that you have to ask one question. You may choose where the question is supposed to come from. So if you want to base the question on his CV, please do so.
My Lord, good evening, and you are welcome. And I congratulate you on your nomination. I want us to take a deep dive into the Constitution. And I want us to go to Article 1273. My Lord, do you have a copy? Very well, my Lord. Article 1273. And it reads, Mr. Chairman, with your permission, a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. End quote. My Lord, do you, in your practice, envisage a situation where this strong shield can be penetrated? Is there any occasion that you think that this ironclad shield can be penetrated?
Yes, my Lord, you have the
Thank
floor.
you.
Honorable Chair, from the reading of the provision where a Superior Court judge has given a decision in the exercise of his judicial power, I don't think that the person can be subjected to any sanctions, because if you make a mistake, the other party has the right to appeal. Thank you, Honorable Chair.
Any follow-up?
Thank you. So, my Lord, your answer suggests a lower court. So maybe at the High Court or at the Court of Appeal you can appeal. But if you are at the Supreme Court, what remedies are available beyond review?
Honorable Chair, if you have given a decision at the Supreme Court and the person is not satisfied, the Supreme Court has the power to review its own decisions where you are able to establish that there are exceptional circumstances. So you can exercise that power if you think that you are not satisfied with the decision of the Supreme Court. Honorable Chair.
I'll proceed to give the floor to Honorable Ewuabafo.
Congratulations, my Lord.
Chair.
At the Supreme Court, you'll be doing interpretation. And so I want to take you through a little exercise. Let's look at Article 1284 of the 1992 Constitution, which talks about appointment. It reads as follows: a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity, and is of not less than 15 years standing as a lawyer. You observe that competence is not a factor for appointment to the Supreme Court. Do you think it is an anomaly? And if so, why?
Honorable Chair, the fact that the provision does not contain the word competent doesn't mean that the competence of any person applying to become a justice of the Supreme Court should not be taken into account, because the person is going to be dealing with interpretation of the laws and so many other jurisdictions that are conferred by the Constitution, and the person must be knowledgeable in the law to be able to qualify as a person for the Supreme Court. Honorable Chair, that is my answer.
Any follow-up? Please do.
And so, if the appointment of a person is being challenged on the basis that the person is not competent, would you, on the basis of Article 1284, say that it is not a requirement on the test, and so that appointment will not be unconstitutional on the test?
Honorable Chair, what I said is that the fact that the word competence has not been used in that provision doesn't mean that the competence in the sense of being qualified enough to do the job should not be taken into consideration. so that because you are going to apply the law and you must be knowledgeable in the law before you can apply it. Thank you, Honorable Chair.
Thank you very much. I proceed to give the floor to Honorable Anthony Mia. Please, you have the floor. 3 questions.
Thank you, Mr. Chairman. Congratulations, my Lord, on your nomination. My Lord, I would like us to look at Article 127 of the Constitution together with 179. The combined effect of 127, 127, 2, 3, 4, and 5, as well as Article 179(4). Basically, it talks about protection of the rule of law, particularly independence of the judiciary, and zooms in. This is where my concern is. Let's zoom in on the administrative expenses of the judiciary. Now, 179, particularly 4, says that the expenditure of the judiciary as presented by the President to Parliament should not be reviewed or varied. I'm a member of the Judiciary Committee, and I'm aware that from time immemorial, budget for the judiciary has been varied, not that of the judicial service. My question is, or I seek your view on the combined effect of this. What would you suggest as some of the possible solutions to curb this? Because your brother, Dennis J.A., just left the seat, and he complained bitterly about insufficient funds for the judiciary to do what is expected. So I want you to give this committee some solutions to curb this problem so that in future there would be no constitutional violation on the part of the executive. The budget of the judiciary would not be cut. Then the judiciary can use the money they need for what they have to do to ensure the independence of the judiciary. Thank you very much.
Honorable Chair, it is true that the judiciary does not have financial independence because it doesn't get all the required funds to be able to carry out its activities. I have been a supervising judge in the eastern region, the northern region, and also in the central region. And you cannot do your job effectively unless funds are available. But the problem is that the judiciary has to depend on the national kick. And so whatever that the judiciary will be given will depend on what is available for the sharing to the other arms of government. Thank you, Honorable Chair.
Any further question?
Yes, I have a follow-up question to this. Would you recommend an action or a writ at the Supreme Court for a proper interpretation of these constitutional